Hello guys, this is Brandon McGee from the McGee Law Firm. We have offices in Fort Worth, Texas and in Southlake, Texas, and we focus our practice on estate planning, guardianship, probate, business entity formation. Things like wills, trust, powers of attorney, Medicaid planning, long-term care planning. And today I want to talk to you about a very specific topic, and I'm going to title this little chat, "Where there's not a will, there's an intestacy." Now, what does that mean? What that means is that in the state of Texas, if you do not have a document such as a last will and testament or a trust that disposes of your estate after you pass away, meaning this document will have the name of the person who is going to be in charge of liquidating your assets and distributing those assets to your beneficiaries, as well as this document will need to name who your beneficiaries are, who's going to get what, more or less. If you don't have a document that does this, you are leaving your family to go through the probate court system here in Texas in a manner called intestate, which basically means with no documents. You do not want to do this. This is a worst case scenario. The reason it's a worst case scenario is, number one, it is the most expensive way to dispose of an estate. You have court fees, you have third-party attorney ad litem fees, you have the fees to hire your family's attorney to take the case to the court system. So it's very expensive. It can also be very time-consuming. This tends, out of all the different ways to administer an estate, to pass down an estate from one generation to the next, this tends to be the most time-consuming as well as the most expensive. Also, with an intestate probate, you're opening the door to family feuds and family bloodbaths. Oftentimes in the legal system, when we see these big family disputes that occur after a parent passes, it's usually when there's nothing left behind stating who's going to be in charge of the estate. So we can have adult children fighting over the control of the estate and who's going to be the one in charge. Also, we can have a big dispute, bloodbath over who's going to get what. Now, when you go through an intestate probate, the court has, or the state of Texas has a very rigid system to determine who's going to get what, and that system is going to need to be followed. However, if you have 4 or 5 different children, 3 different children, sometimes even just 2 different children, they may be arguing over who gets the house and who gets the car and who gets the lake house and those kinds of things. So there's a very simple solution to this problem, okay? And the solution is to have an estate plan in place drafted by a legal professional that states who's going to be in charge of your estate when you pass and who's going to get what. And you can be very specific if you think that your family needs a high level of specificity. You can be very specific with how you leave behind your assets. You can also be fairly general. And if you have 2 kids and you think they get along well, you can just state that, well, one gets 1/2 of my estate and the other gets the other half. So lots of options out there. Like I said at the beginning, you can have a last will and testament. Many of our clients will have a living revocable trust. Some of our clients will have an irrevocable trust. But the important thing is that you consult a legal professional and you get a plan in place that's perfect for your family. And so I want to encourage all of you guys to give us a call here at the McGee Firm, particularly if you're in the DFW area. And we do offer a complimentary consultation for the first consult up to an hour. So any family can come in and speak with me for up to an hour. We will not charge you. And if you have an older estate plan or an out-of-state estate plan, we've got a lot of folks moving into Texas, moving into the DFW area from all over the country. Bring in those old plans and let me review them for you. But I want all you guys to have a great day, great weekend, and give us a call. Thank you.